Welcome to our Landlord and Tenant Rights with COVID-19 webinar. Please let me introduce the president of CAMP, Ms. Audrey. Audrey?
Good morning. Thank you so much, Megan. We so appreciate all your help. I'd just like to say hello to everyone. Happy Monday. Another week in this crazy environment. I just want to also acknowledge Kevin Casey, our president-elect, who's on the call, and Isaac Jacobson, who's kind enough to come and help us with this really timely and important topic. Just a few things before we get going. Membership reminder, just please be a CAMP member. We really appreciate all the people who are joining after these webinars. It seems like you're understanding the value and how important it is to be involved in your industry. And so thank you. So if you haven't renewed this year, please do. If you haven't joined, please do. If you have any questions about any of it, direct your questions to any of us. Well, don't call Isaac. He's not going to help you with that. But Megan, myself, or Kevin are always happy to talk to you about any of those issues. Just want to make sure that you're watching for and participating in our calls to action. So for the federal stuff, we are piggybacking on NAM's calls to action so that those are being put through our system too. And then we should have it like today or tomorrow, hopefully, the state system. So we've covered GSEs, purchasing loans and deferral. We've covered SBA refunding the self-employed borrower loans. And again, next up, we're planning to do a call to action at the state level to address this proposal to slash rents by 25% across the board. So that's on our agenda, and hopefully that will get out this week. Please, it takes a few seconds, no joke, a few seconds to click through these things, but our legislators need to hear from us, and they need to hear from you, and the more the merrier. It's really important, the numbers on this stuff. So with that being said, moving forward, tomorrow we will have our last weekly session with Dave Luna. He had committed to April, which he has done, and it's a ton of work what he's been doing for us. And then we will continue with our weekly updates though on Tuesdays at 11 until this crisis is over. And it will be different people, including we'll bring back David when he's available. So tune in tomorrow at 11. On Thursday, we're going to, by popular demand, bring back Ginger Bell. We had such an amazing response to her presentation on Zoom and video meetings and structuring your virtual marketing plan going forward that we're going to bring her back. We'll do another brief overview of what she covered and then go deeper into the issues and the questions that people had. So that was really helpful for a lot of people. If you know anyone who is interested in taking their 20 hours, we're doing that on Friday and Saturday. Our own Kevin Casey is going to be teaching that live through Mortgage Educators. So 20 hours coming right up. May 15th, Dave Luna will do an 8-hour NMLS class for camp for the state. And then May 28th, Kevin's going to do one for the state, the 8 hours. And just a reminder that during our presentation, feel free to send your questions through the chat bar and we will get them covered. So with no further delay, Isaac, thank you so much for being here today, and tell us, what do we need to know about landlord and tenant rights during COVID?
Okay, thanks Audrey. Thanks for introducing me, and Kevin for inviting me on this. Let's go to the next slide and I'll talk to you about today's goals here. We're going to start by discussing the new California and local emergency residential tenant protections. We're going to talk about a statewide suspension and unlawful detainer lawsuits. Go over some of these local laws and other proposals that might be coming down the line, or just things I'm keeping my eye on, and answer your questions. Let's go to the next slide. We're going to go over questions at the end of this. If you have questions that we don't get to, you can email me, and I'll try to get back to you, or you can contact me. Next slide. Just briefly about myself. Can we go to the next slide here? I'm a landlord and real estate attorney. I am based in San Francisco, and I serve the Greater Bay Area. I represent landlords in landlord-tenant disputes, eviction lawsuits, things like that, and I defend landlords from claims by the tenants. I also represent property owners in disputes with neighbors, title issues, HOA matters, and I've focused on jurisdictions that have a lot of tenant protections, like San Francisco and Oakland. So let's talk about California's response to COVID-19 as it relates to landlord-tenant matters. On March 4th, that's when Governor Newsom declared this state of emergency. And that's going to be important during this presentation because a lot of other orders and laws are tied to that state of emergency. So whenever that is lifted, these other orders may be as well. On March 16th, Governor Newsom issued an executive order authorizing local governments to use their police power to issue orders related to evictions and for non-payment of rent matters. And we'll discuss how those jurisdictions have used that police power since this order. It basically passed along power to local government to deal with this, and many have. And then on March 27th, Governor Newsom issued his own order related to non-payment of rent evictions throughout California. It's Order N3720, and it bans the enforcement of eviction orders for renters affected by COVID-19. Let's go to the next slide. So this March 27th order, I want to talk about it because it was kind of the first order by the state that related to this kind of thing. Although now a lot of these local orders and the suspension of unlawful detainer lawsuits by the courts kind of supersede this. But it's still important to note this could be extended. It could impact us in the future. Basically, Governor Newsom's order, it applies to non-payment of rent evictions, and what it does is it extends that period of time for a tenant to respond to a summons on an unlawful detainer lawsuit from 5 days to 60 days, and gives the tenant an opportunity to cure the rent owed during that time to avoid an eviction. So this requires a little bit of background into how an eviction works. Okay, so when a tenant doesn't pay their rent, you serve them with a 3-day notice to pay rent or quit. The tenant then either pays the rent or quits according to that document, the notice. So they either move out or pay the rent, but they also might do neither of these things. They might not pay the rent, but also continue on the property. And you would have to then file and serve an unlawful detainer lawsuit, which is an eviction lawsuit, and you're seeking a writ from the court directing the sheriff to evict the tenant. So the way that this plays with that process is, you serve the 3-day notice to pay rent or quit, and then you've filed your unlawful detainer lawsuit, and you get that summons, you serve it on the tenant, and usually they only have 5 days to respond. The lawsuit moves very, very quickly. Now they have 60. It slows way down. And as long as the tenant cures the amount owed, they can't be evicted. You cannot get this writ. So let's move on. There's a process that has to be followed by the tenant in order to get this protection. It's a tenant protection. And basically they have to notify the landlord in writing before the rent is due or shortly thereafter that they need to delay some or all of the rent, and they have to retain verifiable documentation supporting that assertion. They don't have to give it to the tenant at that time, but they have to retain it and provide it to the landlord when they pay their rent. Next. And the order describes what sort of reasons qualify the tenant for this tenant protection. And those reasons include not being able to work because they were diagnosed with COVID-19, or that they believed they were, and so they were quarantined, or something to that effect, or they're caring for somebody who has COVID-19, or maybe they were laid off or their hours were reduced, or they had to miss work because of child care. And that the objectively verifiable documentation would have to prove, one of these things. They'd have to be able to show this at the time that they paid their rent. Let's go on. Okay, so that was Governor Newsom's order. And again, it has to do with that time period, that 5-day time period related to a summons for an unlawful detainer lawsuit. But after that, remember that was, I believe, March 26th. On April 6th, the courts issued their own orders, and they did it for all types of lawsuits, but they have a specific order relating to eviction lawsuits. And basically what they said is that this order will be effective until 90 days after the governor lifts that emergency order that he put into place on March 6th, and it suspends the issuance of summons on unlawful detainer lawsuits until that time. So remember, if you serve a 3-day notice or 60-day notice or 30-day notice, at the end of that time, if the tenant doesn't move out or cure, you have to file an unlawful detainer lawsuit. The court would issue you a summons and you'd serve that summons, start the process. What the court is saying is that they will not issue you that summons. It doesn't matter what type of lawsuit it is, whether it was based on a 30-day notice or maybe a 60-day notice, something like, if the tenant was on a month-to-month tenancy and you wanted to terminate it, or if it was because a tenant failed to do something in accordance with their lease, or failed to pay their rent, anything like that. If you serve that notice, file that lawsuit, the court will not issue you that summons until 90 days after Governor Newsom lifts that emergency order. So right now, I believe that order is scheduled to expire sometime in May. I'm almost certain it will be extended, but even if it wasn't, the first time the court would issue you a summons to begin an unlawful detainer lawsuit of any kind would be in the fall or late summer, fall. So that is a huge delay, and again, it could be extended. And the court would just carved out a little exception where, in the court's discretion, they find on the record that the unlawful detainer lawsuit is necessary to protect public health and safety. So that means that any other eviction is suspended. Again, owner move-in evictions we're familiar with, 60-day notices, even the end of a lease term. If the term of a lease ends and the tenant doesn't move out and you have to file an unlawful detainer lawsuit, you would not be able to prosecute that lawsuit until after this period. Let's go to the next slide. Yeah, so again, they carved out this exception for public health and safety. And so what does that mean? Usually we're dealing with things like a breach of a covenant, a nuisance, a tenant committing waste, or doing something illegal. Maybe selling or manufacturing drugs on the property, maybe holding parties or something like that where it's unsafe because of COVID-19. But it has to be tied to that safety issue. And remember, it's in the court's discretion. The court has limited staff right now. They're not able to process things right. They're gonna, probably you're not gonna be able to shoehorn something in there unless it seems pretty serious. So we're pretty much across the board, unless it's a very serious matter, we're not able to prosecute an unlawful detainer lawsuit. And then additionally, in addition to that summons issue, the court is just not going to hold trials. They're not going to default defendants who don't respond to lawsuits, none of that stuff. All of that has stayed through this 90 days. There's a little bit of movement in cases that were already filed, but it's very limited because, again, you can't really get to the end of the lawsuit for now because you can't hold a trial, you can't get a default, nothing. Move on. So to recap those two things that we've talked about, one, Governor Newsom's order says that if a summons is issued for non-payment of rent, basically the tenant has a 60-day period instead of 5 days. So it extends that period after a summons is issued. And then what we just spoke about was that the court is suspending the issuance of that summons by 90 days following the governor's order being lifted. So then now we're going to talk about the local ordinances, because remember, Governor Newsom gave this order on March 16th that said local jurisdictions can pass their own laws that relate to evictions, and many of them have. So first, we're going to talk about the general moratoriums on evictions. And so most major metropolitan jurisdictions, San Francisco has done this, Oakland has done this, San Mateo, all the places around me have done it. They've issued moratoriums on all evictions, okay, with a few little exceptions. And so that basically what that means is during this period of time that this moratorium is in place, again, some of them being tied to the governor's order, some of them just having their own timelines that have been extended or are expected to be extended throughout some portion of the summer. They basically render all notices evicting tenants invalid. You can either, depending on how the ordinance is written, you either cannot issue a notice right now, even if it were to expire after the moratorium ends, you just can't issue it right now. Or if you issued it before the moratorium went into place, say a 60-day notice that was issued in February, in some jurisdictions that one will be invalid. You'd have to just wait and reserve it after the moratorium. In other jurisdictions, you'd have to just wait until the moratorium is over to file an unlawful detainer lawsuit and try to enforce that notice. But yeah, basically you cannot serve any type of notices unless, again, it has to do with some sort of health and safety emergency. Then you may be able to serve it, and it depends on the wording of that ordinance.
Jacob, can I jump in here? We're getting a lot of questions about commercial properties. So can you address, does it apply to, I mean, we know it applies to residential. I know in some cities they've applied it to commercial and residential, but does the statewide moratorium cover commercial? And if so, how does that work?
Yes. So specifically with that court imposed rule, that's all unlawful detainer lawsuits. So in a commercial situation, if a commercial tenant were not to pay their rent, or if they were if their lease ends or something like that, and you terminate their tenancy and you file an unlawful detainer lawsuit, you won't get a summons. You won't get a summons to prosecute that eviction. And so that happens with commercial and to residential. And with these local ordinances, again, every jurisdiction is going to be different, but they generally have passed them as they relate to commercial tenancies as well. In San Francisco, the San Francisco mayor has issued a proclamation and then a bunch of supplements to that proclamation. The fifth supplement is all about residential. The fourth supplement is all about commercial, and it does a very similar. They work very similarly. They basically give the commercial tenant, or they take away the landlord's ability to evict a commercial tenant for non-payment of rent during this period of time, and the commercial tenant can then pay it off given some period of time. Again, every jurisdiction is different, and some jurisdictions also make it so that you cannot impose late fees and other things on those commercial non-payment of rent situations. None of these ordinances. Oh, go ahead.
Oh, sorry. I was going to say, so we have another specific question, and I think that we know the answer based on what you just said, but I just want to make sure. They said, my office building is currently in escrow. Our rents are current. With COVID-19, the escrow is delayed. We have not found a place to relocate. Can the landlord evict us with all that's going on? Sounds like no, correct?
Probably not, and just because there's no way that they can evict. You'd have to look at the local ordinance and see whether they could even start prosecuting an eviction, issue you a notice or file a lawsuit. Some of them are specific to this type of issue. And then again, even if they were able to file that lawsuit, they could never prosecute it. They're stuck. Their hands are tied. That doesn't mean that tenants or their obligations to pay rent are somehow go away. They still are required to pay their rent. It doesn't mean that there could not be a liability for the commercial tenant as far as ultimately having a lawsuit filed against them, or something having to do with the fact they've breached their lease. But they can't be evicted. Most of these, or all of these ordinances, the state laws, all of that, as of right now, they do not change the tenant's obligations generally. They just remove the landlord's ability to evict or to prosecute an eviction, except for the certain rules which relate to like late fees. And some of them say you can't charge a late fee. That changes the obligation under the lease, but that's basically it. So let's go on to the next one. I'll talk a little bit more about these things. So we just talked about general moratoriums on evictions, and remember that would be that would apply to 60-day notices, 30-day notices, evictions related to a breach of the lease. And one thing I wanted to cover there that I just remembered was, I got a call from someone who's about to close on a property. He was buying for himself, and he was going to live there. And he told me, my loan is contingent on me moving in within 60 days, and there are these tenants there. So can we serve them an owner move-in eviction notice now? Or when I close, can you go ahead and serve that for me? And the answer was no, I can't. Not in this jurisdiction. I can't serve that notice. And so if your loan is contingent on you living there within 60 days, you're not going to. They're not going to be able to do that because I can't serve the notice. It would be invalid in that situation. So it's just something to keep in mind for the listeners here with respect to situations like that. Now, in addition to those general moratoriums, these jurisdictions have set up their own procedures for non-payment of rent situations. They have their own commercial ones, and they have their own residential ones. A few examples, and they're all different, but they kind of follow a couple of patterns. San Francisco's tenant can't pay their rent. Let's say it's May 1st, and they're unable to pay their rent. They need to tell their landlord within 30 days, hey, I can't pay my rent. Then they have to follow it up with some documentation. It doesn't have to be detailed documentation. It can be a letter or something like that from their employer or something, right? It says they can't pay their rent. They get an automatic 30-day extension, and then they essentially get 6 months following the end of that order to pay off the obligation before a landlord would be able to evict them. That order was just extended to May 22nd. It was supposed to end on April 22nd. It may get extended past May 22nd. That's how that procedure goes. So it's basically extends the period of time that a tenant can pay off their rent as long as they follow these guidelines. But then there's a separate process that's kind of happening in other jurisdictions. And that process is that a tenant can never be evicted for non-payment of rent due while the emergency order is in place if it was caused by COVID-19. That is so again, we take that May 1st rent, right? It's due, tenant is unable to because they were laid off. That order, let's say that order ends the end of May, June 1st comes around and the tenant pays June 1st. and then the tenant pays August, September, October. They never paid May. In this situation, you can never issue a 3-day notice to pay rent or quit for that May rent. It doesn't matter if it's 6 months down the line or a year. You never do that. You can only, if the landlord could only sue, like in small claims court or something like that, to try to get that money that's owed to them, because remember, the obligation is still there. The tenant's still required to do it. They just can never be evicted for this. And that's a lot stricter, I guess, than any others that I've seen. But we're going to talk in a bit. There are some proposals floating to make all rent in California kind of during this time kind of follow Oakland's model here, which would be that you would not be able to evict for non-payment due to COVID-19 throughout the state if legislation like that was passed. It has not been passed yet or anything like that, but I'm just keeping my eye on that. Let's move on to the next. Yeah, I just wanted to hammer this home. I said it a few times, but the obligation to pay rent has not changed by any of this. The tenant still owes it. Under the commercial leases, tenant owes the rent even if they haven't paid their rent. And under the residential, even with all of these laws, tenant still owes the rent. It's just, what can the landlord do about it? Well, they cannot evict right now, generally. They would have to do something else. They'd have to file a small claims lawsuit. They'd have to wait until these moratoriums end. Whatever they can do, that's what's impacted. It's not the obligation. Tenants aren't getting a free ride technically here, and ultimately the rent comes due. And it can have, implications to, even if you're not evicted, tenants could face a lawsuit, things like that. And commercial tenants have to be really aware whether, if their local ordinance does not forgive late fees, they could be racking up late fees during this time. Even though they're not able to be evicted, they could be racking up these late fees for this period of time that they're not paying their rent. So you have to watch these local rules and see what they say. Let's move on to the next one. Okay, so I want to kind of rehash what I've discussed here. So first of all, and I think most importantly, is this local laws that limit the landlord's right to issue eviction notices for non-payment of rent and other evictions, and to begin the eviction process basically by terminating a tenancy or by declaring a tenancy terminated in some way. These moratoriums generally stop that, and they have special moratoriums on non-payment situations that are different from these other types of evictions. Then the courts have their own rule, and they say, even if you get this notice served, even if you're allowed to proceed, and you file this lawsuit, we're not going to issue you the summons until 90 days after the state of emergency order is lifted. And then the governor has his own rule that says, even if you get that summons, if it was related to COVID-19, the tenant has 60 days, as long as this order is still in place at that time, to cure that rent obligation. And if they do, then they can't be evicted for it. So that's kind of the summary of the different processes. And then I just wanted to touch briefly on just some things I'm keeping my eyes on in the law. Let's go to the next one. Now, these things are not passed. These proposals and legislation, they're not law, and they're different positions right now. But things I'm keeping my eye on that affect this industry. One is this emergency rent and mortgage cancellation legislation at the federal level, which would cancel rent and mortgage payments, during the emergency. This I just seen as a proposal. I don't know, where it's at right now. The next was this proposal that I've discussed with respect to making rent obligations into more of a consumer debt. Basically, tenant still owes them money, but they can't be evicted if it was due to COVID-19. That I haven't seen. I just received some information that that was being floated. I don't know where it's at yet. I don't think it is a legitimate proposal yet, but we should keep an eye on it. I mean, Oakland already passed a law that does exactly the same, essentially. So, people are clearly considering it. And I think that's pretty much what I have prepared as it goes over all of the state and local laws. And now I think I would be ready to open up for questions.
Well, Isaac, we have lots of questions, let me tell you.
Yeah.
So first, let's start with something that's probably fairly cut and dry. So can the security deposit be used for the unpaid rent if so stated in the lease?
Well, so specifically as to commercial tenancies, yes, and the leases are usually permit that, and they permit it during the tenancy. So this is something that landlords who have a good amount of security, some commercial landlords will take a year worth of security, and they can start drawing that down. For a residential tenancy, you have to wait until after the tenancy is terminated to start drawing down, and you have to follow this certain process. So again, ultimately, so let's say that a tenant owes their rent for May, they don't pay it, and the landlord's waiting this period of time before they can file a lawsuit, depending on what jurisdiction they're at, and then the tenant moves out, right? And they never pay this amount owed, and they have this obligation. Well, yeah, you can deduct from the security deposit there if it doesn't cover the full amount that's owed, and then sue the tenant for the remainder. So in those circumstances, yes, but in the interim, you can't really, you can't draw it down basically as the time goes on.
Right. So eventually they could, but they can't during this period.
Yeah, absolutely.
Perfect. And then do you have a sense of what documentation is sufficient for showing hardship? Do you need to get third-party verification, like a letter? You mentioned a letter from your employer saying you've been laid off or something like that, or I mean, what is sufficient? What have you seen or heard?
Every local ordinance is different. I can tell you for the way that San Francisco's works, it doesn't have to be third party. And in fact, the mayor issued some clarification saying third party is not required. It just has to be objectively verifiable, which means that you have to be able to read it and understand that this person is unable to pay their rent because of this. So a letter from an employer would work. A bank statement theoretically would work, but it's not required. It could be almost, I mean, I think that it could be a summary from the tenant explaining what had happened to them. I contracted COVID-19 and then I was unable to work. It's probably good enough, at least in San Francisco. In Oakland, the tenant doesn't have to provide any documentation. They're not required to provide documentation. But the way that the protection works is it's a defense to an unlawful detainer lawsuit. So, a tenant probably should give the documentation. It would save a lot of hassle. But if they don't, and the landlord files an unlawful detainer lawsuit sometime in the future when they're allowed to, and they go through the process of what we call discovery, which is where you serve questions on each other and you depose each other. During that process, you would learn the tenant's financial state and the impacts through documentation or testimony and things like that. So in that situation, documentation is not required. I know that in San Mateo, with respect to commercial tenancies, availing themselves of these tenant protections, there doesn't seem to be a limit on what a commercial landlord can require. They could demand a whole host of documentation and information from the commercial tenant proving that they're unable to pay their rent for some reason. And so it really matters. It's just jurisdiction based.
Well, and we've come up against this as far as the different jurisdictions go, because as we became aware at camp of different places that were putting their own ordinances or rules into place, it is interesting to see how they do vary, but keeping up with each individual locale is tough because there's obviously California is large And so we would ask that our listeners and our members, et cetera, help us stay on top of it. It's a lot. They're all
Yeah, and I would just,
something, and the tenants
I was just going to
tenants
add that
rights
it's
groups
not
are
clear.
so. Oh, I'm sorry, Isaac. Go ahead.
Sorry, I was just going to add that it's very not unclear, the documentation. Some of the ordinances spell it out. They'll say, this is the type of documentation that we're talking about. Others don't mention it. The Oakland one, for instance, it doesn't say anything about what the you have to kind of understand the process to know what they're talking about, which is that they don't have the obligation to prove this up front. It's just a defense that they can raise later in a lawsuit. So you have to, often, talk to an attorney or just be really familiar with how legislation is written, or how the process works to decode the documentation that you can demand or that a tenant can provide. But nothing about these they never seem to limit the documentation that a tenant can provide. And oftentimes it can be helpful to both parties if the tenant goes ahead and just gives some good documentation, some helpful documentation. It can avoid lawsuits later on.
Yeah, well, when we've been involved with these situations and you hear the tenants' rights group speaking, they don't believe that a tenant should be evicted for any reason at all. Like, there is no exception to that. And they feel that it is a function of everyone has a right to housing during this time, et cetera, et cetera. And so with no awareness, apparently, of what the landlord's particular situation might be or how able they are to cope for an extended period of time with no rent, et cetera, or somebody living there who's causing problems. So again, like, for us to stay on top of this it's a big deal, and it's impacting a lot of people all over the place. So
I agree. As a litigator, I do have to say that, ultimately the function of these protections are defenses for tenants, right? Defenses that tenants could raise in an unlawful detainer lawsuit. And you have to think about how a court, how a judge, or how a jury will interpret the tenant's obligation, right? And if you're harping on, I hope that I can prevail in an unlawful detainer lawsuit because a tenant only gave me this type of letter and not a better letter or not a better document. I would caution that we're going to be dealing with juries and judges who are going to be critical of landlords doing that in the future. So at least in my practice, I'm liberally construing these defenses to say, if the tenant gives me some kind of document, something that seems like it's legit, we should take that as probably good enough, depending on the jurisdiction, I guess.
Gotcha. So someone is asking specifically, what happens if the lease expires on May 31st? Am I required to renew their lease or can I ask them to vacate?
Jurisdiction specific, but if some jurisdictions specifically say you cannot pursue an eviction where a term of a lease ends. But some of you can. It's just that you could file the lawsuit in that jurisdiction, but you would just not be able to proceed. So you can ask them to leave in those jurisdictions, or you can say nothing and see if they leave, or you can allow it to roll over to a month-to-month, or you can sign a new lease, or you can, again, if it's a jurisdiction where you're not allowed to proceed with an eviction until after some period of time, you just wait until that period of time. If you don't want it to be a month-to-month, maybe don't accept rent, depending on what the lease says, and then file the eviction lawsuit at the first available time.
It sounds like people would be well served to consult an expert when they're dealing with their particular situation in their particular jurisdiction, right?
Right, because also
it sounds like it could be a minefield.
Yeah, absolutely, and some jurisdictions wouldn't allow you to evict at the end of a term anyway, under the California's new eviction protection ordinance, or if you are in San Francisco or Oakland or West Hollywood, one of these places that don't allow you to evict at the end of a term anyway. So yeah, consulting with an attorney would be very helpful.
So here's something very specific. Can a landlord in Redondo Beach, California, still raise the rent the 8% allowed at the end of the tenant's lease with a 60-day notice of increase?
I don't know what Redondo, if they have a local law that says that you cannot. Certain ordinances are limiting rent increases, but generally they aren't. And so, I mean, for most of them, you can still issue rent increase notices on 60-day notice. 8% would be generally, as long as there's not a rent control ordinance that limits that, generally you'd be able to. There is, because there's an emergency order in place, there are price gouging laws in place, limiting rent increases to 10%. Again, you should look at, you probably consult with an attorney on that, but it is considered price gouging to raise the rent past 10% right now, in generally.
Hey, Isaac, it's Kevin.
Yeah.
I also have some people who are private money lenders on the call. One of them asked, can a private money lender still go ahead and sell property in foreclosure if the property owner was in default before 3/16? The property is in Santa Clara.
Yeah, so I am not an expert on, I haven't been following the foreclosure laws. There are moratoriums on it that go into effect, but I don't handle any sort of foreclosure issues.
Thank you.
Yeah.
So someone is asking whether you can give a specific comparison between the old eviction timeline versus the new eviction timeline? So for example, if the tenant hasn't paid its April rent due to COVID-19, what can landlords do? And it sounds like there is no eviction timeline now until
Right.
this ends. Is that correct?
So generally what we would do, let's say April 1st, 2019 rolls around. They don't pay their rent. We issue a 3-day notice to pay rent or quit. They don't pay by the end of that, and they don't quit. They don't move out. So we file a lawsuit on that 4th day, and we serve a summons, assuming we can find the tenant right away. Serve that summons right away. And they have 5 days to respond to that summons. They respond within that 5 days. We can demand a court date as long as we're working really quickly. We can get a court date within 21 days of our request for a court date. We get that trial date. Let's assume we go to trial and prevail. It takes like a week. We get a writ from the sheriff. The writ needs to be executed within 3 weeks, and the sheriff evicts the tenant by the end of that. So we're looking at 40 days to 60 days. There's sometimes delays, there's sometimes things that happen, but you can go from the beginning to the end in that period on a 3-day notice. Now, tenant doesn't pay their rent in April. Depending on your jurisdiction, right now, let's say you're in San Francisco, the first day that you can issue a notice, at least under the current ordinance, would be May 22nd. You wait until May 22nd. And let's say they don't follow any of these extensions to get 6 months or something like that. They don't follow any of the laws. You're able to issue that 3-day notice. They don't pay it, and you file your lawsuit. Now we're waiting until the governor lifts his order, an emergency order. Let's say that is lifted until let's say, end of May. We would be waiting 90 days until the court will issue their summons. So 90 days after June 1st in this scenario, unless everything is extended, which I kind of expect. Then after that 90 days, you get a summons, you serve it, and that starts that process. And again, the timeline could be even extended further by the tenant availing themselves of the 6-month extension period that San Francisco has.
Now might be a good time to remind people that even though it's clunky and I've heard it's frozen up a few times this morning, you can apply as landlord for some SBA relief. So I don't know if you'll get it, but it's available to landlords. And, as we talk about all this, and there's very little conversation about how to assist landlords in dealing with this crisis. It really is so focused on the tenants and their plight and how difficult it is for them, with almost no recognition that the landlords still have to make the property tax payments and the insurance payments, et cetera, and pay all the expenses. And so, yes.
Right. There's not a global solution right now, but I do recommend that my clients apply for these SBA loans. And, the tenants still are obligated to pay these rent obligations. So, there's other solutions that can be made. Landlords can reach separate agreements with their tenants to pay off the rent obligation over time or something like that. There's not a lot for the landlords right now.
Nope. There is, I think we know the answer at this point, but just to clarify, this all applies to single family as well as multifamily properties, correct?
Correct. It applies to all of them. Certain jurisdictions will also have additional protections for, say, multi-unit places. Again, Oakland is limiting rent increases now, but only to the multi-unit buildings covered under the local rent increase, rent control law. But all this other stuff applies pretty much across the board.
This is an interesting one, and I don't know if you'll be able to answer it, but let's give it a shot, shall we? So
Sure.
7 years ago, someone had a mother of 2 minors sign a lease, and since then the mom died. She died 5 months ago, and the minors are both adults now, and they're not on the lease. Can they be evicted for non-payment if they are not on the lease? And they're actually asking specifically if they can be evicted more quickly if they're not on the lease. But if they're not on the lease, but they're living there and not paying rent, can they get a judgment against them? And I think they have to wait till all this is over, probably. But you tell us.
When you issue a 3-day notice under normal rules, it encompasses all other occupants, including anyone holding under the leaseholder. And the eviction lawsuit will include those subtenants or those other occupants. So yes, you can evict anybody living in a property if the leaseholder, the master tenant, or whoever it was, the last person to sign a lease, didn't pay their rent. But you cannot evict more quickly. There's one way of evicting people for non-payment of rent, and that's it. And right now, you're limited by these local state rules.
So they're asking, where do we go to find the local rules of each jurisdiction? Do you know a central spot where people can go check that out, or do they have to do some digging within their own locale?
You would look in your own locale. I mean, San Francisco's were issued by the mayor. Some of them are countywide. So you would just look at the county's website, or the mayor's website or something like that. That's where it's going to come out of.
Right. And somebody's asking, what if the tenants want to break their lease early? Can they break the lease agreement and move out during this time? So on the opposite end of it, interesting question.
Well, they're still obligated under the lease. None of the rules say that the lease obligations are changed in any way. So they could theoretically move. They could stop paying their rent, but the landlord has the same remedies that they would have against the tenant. They could maybe sue for the unpaid rent for the duration of the term, or any other damages, things like that. So tenants are not relieved from those obligations. You just might be delayed in bringing a lawsuit like that because of the way that the courts are structured. And tenants are able to move. People are able to move during this time, and they do.
Right. I have a friend. Their landlord was happy for them to leave. They've been wanting to get rid of all their tenants, so they were able to move. So I guess it just depends on whether there's an agreement between landlord and tenant. Yeah.
Yeah.
So here's a question about, can you address if there's a leniency of evictions on tenants who were never on the lease or rental agreement? It kind of goes back to that same question, but it is an interesting question if there are different rules for people who are on the lease versus people who are living there who are not on the lease.
Generally, no. The unlawful detainer lawsuit itself will encompass everybody that's living at the property. And assuming that the tenancy has been properly terminated and you prevail in the unlawful detainer lawsuit, that judgment will attach to everybody that was occupying the property. All their names will be on the lawsuit. They'll all be evicted by the sheriff. Now, and when you serve a 3-day notice to pay rent or quit, everybody living there was obligated to pay that rent, and so that covers them as well. Certainly, with certain jurisdictions, tenants who are on the lease might have additional protections. In San Francisco, for instance, a approved occupant might be entitled to, say, relocation money in certain types of evictions, and maybe an unknown subtenant might not be. But generally, evictions cover everybody. Everybody gets evicted by the sheriff at the end. Everybody gets a judgment against them, regardless of who they are or why they're there.
So you had mentioned in the beginning that if the tenant wasn't able to pay their rent, they need to notify the landlord. What if they don't? What if they just don't notify and they just don't pay their rent? Then are the rules the same or different?
It's jurisdictional, but for instance, in the San Francisco one, they're required to make that notice to the landlord in order to get this additional protection of having 6 months to pay off the rent without the risk of eviction. If they never notify the landlord, they never do anything, and the landlord just waits until this other moratorium ends. There's a 60-day moratorium on all evictions. The landlord just quietly waits until the end of that date. They can issue a 3-day notice and evict on that date, and the tenant doesn't get this extra protection. So it depends again on the jurisdiction, but the tenant may be required to give that notice. And in Oakland, they're not required to give any notice at all. Yeah.
Shocking. No, just kidding. Not shocking. Kevin, do you have anything else to add?
Yeah, I do, and I'm going to add it to one of the questions in the beginning. And someone asked, how does the COVID impact rent increases going forward? They said their understanding is that annual rent increases cannot be banked. If COVID crisis continues through this year, will we lose the ability to increase altogether going forward? I think I know the answer to that one, but I have a follow-up to the question.
Well, it depends on the jurisdiction, right? Because and the property, because some properties don't have limits on rent increases, but for right now the price gouging limits that are imposed by the state. If you're talking about banking, you have to look at the jurisdiction that has a banking ordinance, like San Francisco's, that allows banking. Meaning if you don't raise the rent this year, and in the future you want to raise the rent for past rent increases that you missed, that you were allowed to do, if you're permitted to in the future, then yeah, I haven't seen an ordinance come down and say banking in San Francisco, for instance, is not permitted. And there's no banking law on the state rent ordinance that went into effect on January 1st.
All right. And then my follow-up to that one, and just something from the last conference we did, you mentioned this, as I thought was brilliant. That was, what if you are a landlord, you have a tenant that's got a problem, and you decide to work it out and say, hey, listen, just give me half the rent. Have you lowered your rent now and you can only increase it off that amount? You can't put it back, or do you have to be careful of that?
Yeah, it really depends on the jurisdiction. But for instance, in San Francisco, we have this rent protection ordinance. It basically limits your ability to raise the rent every year. And you have a base rent, which was basically what the rent was when you started the lease. And then you've got these incremental rent increases every year that you're allowed to do. And in certain circumstances, if you lower the rent for the tenant because of something that happened for the tenant, the tenant was injured and couldn't work, and they asked you to lower their rent. You could do that, and then at the end of that, when they're better and they have their job back, you could raise it back up, and you wouldn't be punished by the rent board or the courts. But in the past, if you lowered the rent because of a market change, right, because of the recession in 2008, and then you say, okay, well, I want to raise it back up because now the market's doing better, everyone's got more money. The rent board would say, no, no, no. When you lowered the rent, that became the new base rent, and you're not allowed to raise it back up. And so your incremental rent increases are always going to be off that lowered rent from now on. And so we just have to be cautious now when in jurisdictions like this, if you want to lower the rent for a tenant, you probably can for a brief period of time. Say you want to cut the rent in half for April or May, but you need to have a clear document, a clear contract with them explaining this is temporary. It's for you personally. It's not because of a market shift. It's because you lost your job or you have this economic impact. That way, once this is all over and you want to raise it back up, you're not challenged by the rent board or the courts.
Excellent. Thank you.
Yeah.
Wow. That's a lot, Isaac. We are coming to the end of our time, and I just want to say thank you so very much. That was a lot of very important and useful information, and I would just invite people to remember that you need to check your specific situation with your current city or county or whatever applies to you and your property. And if you need an attorney or need some extra advice, definitely get in touch with somebody. Good Lord.
Absolutely.
Amazing. Thank you so much. So just to recap, tomorrow we have Dave Luna. Thursday we have Ginger Bell. And then Friday and Saturday we have the 20-hour. And we're putting together a social cocktail party too. So watch for the invite on that. And with that, I would just say thank you again to Megan Jackson and Kevin Casey. Isaac Jacobson, you were great. Have a great week and a great month. And I will look forward to hearing from everyone next. Bye, everyone.
Thanks, Audrey. Bye, everyone.
Bye-bye.